constantly referring to, you can just prepare a little one-page index for us. Just not everything, just on one page. Things which now we know everybody is referring to it. So it does become very easy for us to.
Number of several volumes, 6 volumes are there.
Yeah, but ultimately from the 6 volumes, there are about, say, 20 documents which everybody is referring to. Those, if you can put down on one page with the volume number, it just becomes easy for us. We can keep it on the dais and just flip through it whenever.
Volume 1, page number 54.
What that page?
The Constitution of India supplied to Jammu.
No, that is at, I think, page 13.
Volume 3.
Yes, page 13, that's right.
Page 13.
Achha, one may be here.
Volume
page
3,
one.
page 60.
So, you are or you are referring to the Constitution as applicable to the.
Bhushan, Constitution is applicable.
Has all the learned judges got it or no? Your Lordship has got it?
One is in the GO and the CO and the other is the Constitution. It's the same. 151 मिल गया आपको ना? मिल गया 150.
Should I read it? Your Lordship got it?
Yes.
What does it say? Now, 253 deals with international treaties and agreements and conventions, provided that after the commencement of the constitutional application of Jammu Kashmir Order 1954, no decision affecting the disposition of the state of Jammu and Kashmir shall be made by the government of India without the consent of the government of that state. What is being recognized?
Disposition of
What's
the-
being recognized here? This is what I'm saying.
What is meant by disposition actually? I just.
Yes, final disposition, which would mean in 1954, the government of India concurs with the government of Jammu and Kashmir that the final disposition of the state of Jammu and Kashmir has yet to take place.
No, decision.
Just read it once again.
Disposition of the state.
Sorry?
What is meant by disposition actually?
Not settlement. Disposition would mean settlement.
Yes, they agree with what we can't say. Because in that context, the whole story in the past.
This is in my humble submission, of course, there are different perceptions of it. This is the recognition of that position which preceded enactment of Article
This
37.
also doesn't mean that all treaties will not apply to J&K. For instance, suppose the Universal Declaration of Human Rights or the Covenant on Civil and Political Rights, that would apply. Or say the Convention on the Elimination of Discrimination Against Women,
only on-
that will all apply, right?
We're only on the point of the state's disposition.
The state's disposition.
Now, when we talk of state's disposition, I had already entered into instrument of accession. What does it mean that the state has yet to be disposed and will be done by government of India only with the consent of the government of Jammu and Kashmir? Where would it apply? This situation will apply where? This is concurred by both the governments. It's not unilateral action. I would submit, this is the recognition of this submission which I made yesterday, that this issue has an external dimension, which is recognized in this. It has an internal dimension, which is also recognized in this. And both went together with Article 370, clearly carve out a position that state of Jammu and Kashmir has a distinct position pending its disposition. Final disposition. So what I am submitting is that this state of Jammu and Kashmir, all judgments of this court बच गए कितने हुए बच गए कितने टाइम क्या हुआ हैं 10 to 1 Yeah. So, time. छोड़ो ना समझा थोड़ी मांगे अब नहीं बोल So, my lords, the premises on which I am building up my case is this: that state of Jammu Kashmir, as all judgments of this court show, has a special and a peculiar position. It is for the first time this court is called upon on a very important issue, whether this can, the way it has been got rid of, whether it could have been done like that. And that does not involve any issue of the procedure involved. It also involves the issue of power. Isn't it something which is basic to all the arguments raised before this court with regard to the power? The power of parliament, the power of president, the power of the government of the state, the power of the governor. The common theme in all these constitutional authorities is the power. And we're examining that issue, we're debating that issue, that something has been done, whether you had the power to do so. This is one. Second, how did you exercise that power? And if the exercise of the power is unconstitutional, then even if you have that power, the action will still have to be invalidated. This seems to be the theme of the whole thing. There, ultimately, whether 370 by itself subserves the sovereignty, as I said, it does. But at the same time, this sovereignty is exercised by it from time to time by agreeing to all constitutional orders passed, 54 in number, how those constitutional orders were passed, how they are passed, and what is the effect of those is also an issue. Then also, what is it that we are claiming? We're only claiming constitutional autonomy, which has been taken away from us on 5th of August and 6th of August. Now, how do we get that constitutional autonomy back? Is by demonstrating to the court that what is that I had. If I had nothing, then what am I fighting for? It will be an unrealistic litigation, unworkable litigation. It will have no result at the end. Second would be I still had the constitutional autonomy, maybe little, maybe whatever it may be, as Honorable Justice Kof observed, you are talking of a skeleton. Maybe it was a skeleton, but somebody still felt that skeleton was disturbing him, therefore he got rid of it. If it was a skeleton, leave it as it is. The way we were living prior to 4th of August 2019, then the things remain as they are. But then the thought of removing this skeleton, somebody must have thought somewhere that this skeleton must also go. But I am not on the question of this skeleton. I still had the power. Now let's see what was in the Constitution. What was the constitutional application order, in particular 1954? Why? Because it is that order which is amended from time to time. And then what was sought to be protected? Can I say something more, Millers? We are protecting, let's say, the individuals who live in the state of Jammu and Kashmir as permanent residents. Now that is protected under the Constitution as applied to us. I'm just saying that is protected. That was protected earlier also in terms of the notification of 1927. And interestingly, at that point of time, agitation was raised by a community, my lords. Unfortunately, they left us and we owe a lot to that community because we were taught by that community. Anyway, that apart, they agitated because they were the educated class, and the king at that time would get people from Punjab and other areas. So they said, we need jobs. So they agitated, and that resulted in a notification of 1927 and restricted appointments to the permanent residents. That subsequently there was a notification 1932 that also restricted. Now, when that is protected, now it has protected for several reasons. One could be that, look here, it is meant for the jobs, it is meant for the acquisition of the properties. Second also could be that, look here, the state as it is, so the people who live there need to have some rights, some privileges as against others. So they all protection came, that's one. Number two, state itself. Keep the state intact, though we are three regions. We're Ladakh region, Kashmir region, and Jammu region. The Maharaja at that point of time thought that bring all the three regions together, and then we became a state. To protect the whole state. Now what has been done? It has been divided. The people are divided. The part of it is with Pakistan, the part of it is with China. About 2,000 kilometers are with China in Aksai Chan. Part of it is with Pakistan, and remaining part is here. We're getting sandwiched between all these forces which are applying in the state of Jammu and Kashmir. Now, by virtue of this, again, the people have been divided now. Now we're reduced to a union territory of only Jammu and Kashmir, and Ladakh has been separated from us. Somewhere, somebody, when they say how to make a law, somebody was asked, a lawyer who was involved in how to make it, he told him, you tell me the political decision, I will tell you the law. Law does not precede political decisions. First, some politics comes in, then the laws come. So looking at the laws as they have been framed, somebody took these decisions to make divisions and further divisions to our state. Now we are claiming a position which it was on 4th of August. We need to be reunited with all the three regions. We need to live as we used to live. And then, of course, over the passage of time, as the government of the state, as I'm not on the wisdom of that, rightly or wrongly, government of the state from time to time did agree, did give its concurrence to the application of various laws from time to time. But nevertheless, there were some fundamental laws to which they have not agreed in the 69 years. Now, for the first time, now this proviso which is added to Article 3, this continues as it is. Now, entry 97, your lordship just read. Entry 97 is the residual power of the Union Parliament. If any of the subject of legislation does not fall in all those 96 entries, but yet it will be covered by entry 97. It means it is open. If any legislation does not fall either in state list or concurrent list and is made by Parliament, it will fall in entry 97. When it is made applicable to us, it is made applicable to us in a specified manner. Now, what is that specified manner? In 1985, the Parliament enacted Terrorist and Disruptive Activities Act, commonly known as TADA. That did not apply to us. The government at that point of time, I still remember 6th of June, 1985, it recommended to the government of India, please apply this entry 97, but restrict it to the matters which your lordship read just now, questioning the integration of the state, questioning the accession, so on and so forth. Please apply that entry. Accordingly, this entry came to be applied. It would imply that entry 97 as such, with widest possible power under entry 97, does not apply to the state of Jammu and Kashmir. It applies on a specified issue of a subject matter of a legislation. This, for example, I'm indicating another autonomy which I have. I have the autonomy of permanent residence. I had the autonomy of alteration of my state. I had the autonomy of final disposition. I had the autonomy of entry 97. Then there are similar other entries, both in the concurrent list as well as the list one. So I will give you a long list of the entries which apply to us with modifications. And those modifications carve out the constitutional position, the constitutional autonomy which the state enjoyed. Now, see another important thing. The laws of this country obviously give rights to the citizens of this country. That's in terms of the fundamental rights and so on and so forth under the Constitution and under various laws. Now, these laws come into conflict with some of the laws which were applicable in the state of Jammu and Kashmir. In order to protect those laws, what the president did in 1954 order, he incorporated a new article, that is 35A. Incorporated a new article, that is 35A. It is not in the Constitution of India. Obviously, it cannot be in the Constitution of India. It is in the presidential order of 1954. He carved out this Article 35A with the concurrence of the two governments, protecting the employment, the permanent residency, the scholarship. I will indicate that also to your lordships. He protected that as well. Now, this protection, this kind of protection, Article 3, 253, entry 97, all these do indicate I still had constitutional autonomy. It is not that I was completely reduced to a skeleton. Maybe I was on oxygen, but I still was living. I still had that constitutional autonomy in terms of this constitutional position. And I continued with that. Whether this was rightly done or wrongly done, nobody is questioning that wisdom. I mean, that's entirely for the government of the state. And between them, not even the government of the state, but the council of the state. Now see, Parliament is excluded under Article 370. State legislature is also excluded under Article 370. It is the president, the governor, and the council of ministers. That is all. These three are there in Article 370. They can do, undo with the Constitution.
Yes.
And my lords, learned judges talk to each other is always mysterious to us. They don't share their views to us, so that we can answer them.
It's the
Whether
same
they are
way,
Positive, negative, or what their responses are.
sometimes the same way when lawyers talks that not necessarily everything is.
So, my lords, I'll just indicate to your lordships now the constitutional autonomy of the state, which still was intact. Which is important because that's what we're striving at. That please help us to maintain this constitutional autonomy. What has happened in the past, and also what kind of governments we'll have in future. It is for them to extend these laws to us. But we need our constitutional autonomy. Now, what is it that we had prior to 5th of August 2019? One, your lordship may have a look at this 1954 order, which is the basis of the order because all other orders have subsequently been amended. And I worked on that and I will show the kind of amendments made under various council orders from time to time. Let me begin with 1954 order.
What page, Mr.?
It's volume 3, page 13. Volume 3, page 13.
Sir, I think you lordship also need to compare it. What is it that was done simultaneously with the Constitution of India? Yes,
Looking to see your.
that is Constitution Application Order of 14th May 1954. Is volume में यार ये? Volume 3, page 406. General page?
1954. 1954.
Yeah, 54.
PDF page 30.
PDF page?
13.
PDF page 13. In exercise of powers conferred clause 1 of Article 370 of Constitution, constitute the president with the concurrence of the government of state. Is pleased to make the following order. This order may be called Constitutional Application Jammu and Kashmir Order 1954. It shall come into force on the 14th day of May 54 and shall thereupon supersede Constitution Application of Jammu and Kashmir Order 1950. But I may remind here, this is the stage when Constituent Assembly of the state was in session and was making the Constitution of the state. The provisions of the Constitution, which in addition to Article 1 and Article 370, because that is already stated in 370, shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply shall be as follows. The preamble remains as it is. Part 1 remains as it is, but to Article 3, there shall be added the following further proviso. I wait here, also just have a look. What does Article 3 deal with? It deals with formation of new states and alteration of areas, boundaries, or names of exist. Parliament may by law form a new state by separation of territory from any state or by uniting two or more states or parts of states or by uniting any territory to a part of any state, increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state, provided that no bill for the purpose shall be introduced in either house of the parliament except on the recommendations of the president, and unless where the proposed contained in the bill affects the area, boundaries, or name of any of the state, the bill has been referred by the president to the legislature of that state for expressing its views thereon within such period as may be specified in the reference or within such further period as the president may allow, and the period so specified allowed is expired. Explanation why in this article clause A to E, state includes a unit territory, but in the proviso state does not include a unit territory. Explanation 2, the power conferred on parliament clause A includes the power to form a new state or unitary by uniting a part of any state or unit territory or to any other state or unit territory. Now, my lords, insofar as the order is concerned, to Article 3, there shall be added the following proviso, provided that provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of that state. This is the restriction imposed with regard to the power of the president and the parliament to do away with the boundaries, the names of the various states. Then, sir, Your Lordship will kindly see 7. Right of citizenship of certain migrants to Pakistan, notwithstanding anything in Article 5, and a person who has after the first day of March 1947 migrated from the territory of India to the territory now included in Pakistan shall not be deemed to be a citizen of India, provided that nothing in this article shall apply to a person who, after having so migrated to the territory now including Pakistan, has returned to the territory of India under the permit for resettlement or permanent return issued by or under the authority of any law, and every said person shall, for the purpose of Clause B of Article 6, be deemed to have migrated to the territory of India after the 19th day of July 1948. That Your Lordship will see now what is added to it. यार चलो इसको क्या हो जाता है? हमारा ही चलता ही नहीं है. To Article 7, there shall be added the following further provision, namely provided further that nothing in this article shall apply to a permanent resident of the state of Jammu and Kashmir who, after having so migrated to the territory now included in Pakistan, returns to the territory of that state under a permit for resettlement in that state or permanent return issued by or under the authority of any law made by legislature of that state, and every such person shall be deemed to be a citizen of India. It's altogether a different provision. The law power to provide for resettlement vests in the legislature of the state, and such person shall be deemed to be a citizen of India. This is the modification made in 7. Then, sir,
Mr. Zafar Shah, is it because part of the valley, a part of Kashmir remained in Pakistan occupied? Was that the reason for this basis?
so I could not.
Was the reason for this, as you are saying this is different, that a part of the state remained occupied by Pakistan? So is that the basis for it? Because there may be people who may be there and may be coming here. Is that the basis for this?
Not only that, there could be something more. Prior to 1947, there were many areas like Gilgit and other areas where the people of the state who were working under the king were transferred. I know a case that happened to me. They were transferred. An engineer was transferred to Gilgit. Then 47 happened. What do we do with him? This provided a method that if you want to come back, originally he was the citizen of this country. If you want to come back, you will do so only under the Resettlement Act, to be passed not by Parliament. In the case which I read to you, also it's the Parliament which has the power. Here, the power vests in the state legislature that he can come back under this resettlement. So all those people, and important thing is, they shall be deemed to be citizens of India. Means they have not abandoned the citizenship of this country by dint of having been posted there or dint of being there prior to the partition of this country, prior to the part having been taken by them. Of course, that would include that also. The people who got separated, who are now with the Pak-occupied Kashmir, of course, the people who still have relationships in Kashmir, those are across the border, they are here. Those are the practical problems faced by the governments, social problems, people's human problems. They wanted to come back. Somebody wanted to die. I know many cases in Kashmir, this happened in the High Court. They wanted to die in Kashmir, but they could not come. This Muzaffarabad road was opened. They wanted to come. It then got discontinued for political reasons. So therefore, this kind of a provision only enabled the state legislature to make the law. If they want to come, of course, subject to the conditions of that law. Whether you have voluntarily given up the citizenship of India, then you cannot come. But if you are by dint of a situation and the circumstances, you are stuck up in another place and you want to come back, After the things become normal, obviously a person cannot come when there is a conflict. When peace is returned, you can come back, nothing is wrong with you, that you never intended to stay there, but because of certain circumstances. So I would say this kind of an power, all I'm today indicating, Lordship, is the power, what we call as constitutional autonomy, which I have. It is in that context I'm saying, here I had the power to make the law.
Was large number of certificate issued just as a matter of
That
information.
was, sometime that was made, I remember that, Your Lordship is.
Yes,
Yes,
they issued some of them.
yes. Actually, then, sir. And it has solar काम हो जाता. It's 2 and it's 3 does not. Then will also may kindly see this part 3 of this order. Now it talks of some of the, I may not read them with regard to Article 16, to whom it will apply for a period of 5 years. That is what is important. And then in 4 and 7, that is the case which went to the Supreme Court in Sampat Prakash and other cases. In clause 4 and 7 of Article 22, for the word parliament, the word the legislature of the state shall be substituted. Now see what is this 22, 4 and 7. Four talks of no law providing the preventive detention shall authorize the detention of a person for a longer period than 3 months, unless an advisory board consider persons who are or have been or qualified to be appointed judge of a high court has reported before the expiration of the said period of 3 months that there is in its opinion sufficient cause for such detention. Provided nothing in this subsection shall authorize the detention of any person beyond the maximum prescribed by the law made by Parliament under subclause B of clause 7, or such person is detained in accordance with the provisions of any law made by Parliament under subclause A and B of clause 7. When any person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order shall as soon as may be communicate to such person the grounds on which the order has been made and shall afford him the earliest opportunity of making a representation against the order. Nothing in clause 5 requires the authority making it so as to refer in that clause to disclose fact which such authority considers to be against the public interest to disclose. Parliament may by law prescribe the circumstances under which and the class of cases in which a person may be detained for a period longer than 3 months under any law providing for preventive detention without obtaining the opinion of an advisory board in accordance with the provisions of subclause A of clause 4, the maximum period for which any person may in any class of cases be detained under any law providing for preventive detention, the procedure to be followed by an advisory board in an inquiry under subclause A of clause 4. Now see, sir, what it says. In clause 4 and 7 of Article 20, the word parliament, the words legislature of the state shall be substituted. So the law of preventive detention can be enacted only by state legislature, not by parliament. I must make one thing clear here, sir. Some of the laws may be in a sense duplicate copies of the central laws. Just duplicate copies of this, maybe full stop, commas and this. But what is important is the power to make the law. It may be, state legislature could make the same law as it did, as this preventive detention law is applicable to the rest of the country. But the question is on your power. We say that this power exists only in the state legislature to make the law preventive detention, and that is how Public Safety Act has been enacted in the state of Jammu and Kashmir. It is that power which matters. Otherwise, laws may be the same. It's possible. Like we had Ranbir Penal Code, we used to call it. In the rest of the country, they called it Indian Penal Code. The difference was in the name. But the question was only a power. Our legislature could amend RPC, what we normally use called a Ranbir Penal Code, but obviously it cannot amend IPC, Indian Penal Code. Provision may be identical, provision may be same. But what is important to be considered, the power to make that law, the power to amend that law, the power to repeal that law. It is that power which gives us constitutional autonomy. 31. इसमें 31 चलो पुरानी किताब निकालो चलो इसमें 31 29 इसमें भी मिसिंग है मेरा उसमें मेरी फाइलों में जरा इसमें निकालो ये मेरी इसमें कॉन्स्टिट्यूशन ऑफ इंडिया होगा
Yes.
Sir, then we have this Article 31, which was in existence at that point of time. I have a copy of the original constitution as it was adopted in 1949. You also will not have this Article 31 in the book, which now is because it stands repeal deleted, and we are now instead of 300A, it just ceases to be fundamental right. But I just read it from the original constitution. No person shall be deprived of his property save by authority of law. No property movable or immovable, including any interest in or in any company owning any commercial or industrial undertaking, shall be taken possession of or acquired for public purposes under any law, authorize the taking of such possession or such acquisition, unless the law provides for compensation for the property taken possession of or acquired, and either fixes the amount of the compensation or specifies the principles on which and the manner in which the compensation is to be determined and given. No such law as is referred to in clause 2 made by legislature of a state shall have effect unless such law, having been reserved for the consideration of the president, has received his assent. If any bill pending at the commencement of this constitution, the legislature of a state has, after it has been passed by such legislature, been reserved for the consideration of the president and has received his assent, then notwithstanding anything in this constitution, it is there? They have it? Yeah, they. Okay. Your lordship also has this, like that small book.
Yes.
Oh, yeah. if any bill pending at the commencement of the constitutional legislature of a state has after been passed by such legislature been reserved for the council of president and has received his assent, then not telling anything in the constitution, the law so assented to shall not be called in question any court on the ground that it contains provisions of clause 2. Nothing in clause 2 shall affect the provision of existing law other than a law with the provision of clause 6 apply. The provision of any law which the state may hereinafter make for the purpose and enforcement levying any tax or penalty or for the promotion of public health or the prevention of danger to life or property or in pursuance of any agreement entered into between the government of the Dominion of India or the government of India and the government of any other country or otherwise with respect to property declared by law to be evacuated property, any law of the state enacted not more than 18 months before the commencement of this constitution may within 3 months from such comments will be submitted to the president for his certification. And thereupon, if the president by public notification so certifies, it shall not be called in question any court on the ground that it contravenes the provisions of clause 2 of this article or has contravened the provision of subclause 2 of section 299 of the Government of India Act 1935. Now, see, sir, this clause 5 has been substituted under this 54 order. It says nothing in clause 2. First is in article clause 3, 4 and 6 shall be omitted. So we have omission with regard to the power of the parliament. That if I pass a law, it was to be reserved for the assent of the president. I don't have to do that. Our state legislature has not to do that. This that's deleted.
Really trying to say is that under the 1954 CO, there were extensive amendments which were made to the adaptations or modifications were made to the Indian Constitution. There are provisions which were deleted, other provisions which were applied with modifications. In fact, interestingly, Article 136 was omitted.
Yes, 136 is omitted. So what I am trying
So
to
we
say,
get that point. We get what does that lead us up to actually?
what argument is this? That when we have a bird's eye view on 1954 order, there are some smaller matters which are matters of internal administration. Then there are some fundamental ones. Like I read, for example, the proviso to Article 13, Article 3, that you cannot alter the boundaries.
Yes.
Now, that is a fundamental concurrence between the two governments. I read Article 7 with regard to the permanent residence. That's something fundamental in 54 order. So what I am trying to show is that there are orders which go to the very root of the matter and which continue to remain as they are till date. They have not been diluted. Subsequently, other provisions like 356 subsequently applied, 136 subsequently applied, but they are matters between the union and the state. But then on the broader parameters, the state continued to have its autonomy. That's all I am trying to indicate. By virtue of each and every, I have noted each and every article. It deals with what was the subject matter of the article in the Constitution, and how by the order of 1954, a certain position, especially for Jammu Kashmir, was carved out.
Mr. Shah, can you just, to sort of summarize, can you tell us on the eve of the CO of 5th of August 19, which were the key provisions of the Constitution to which an exception still existed in relation to Jammu and Kashmir?
So let us say Article 3.
So we can really summarize those because that will give us the net position as on the date.
Very true, sir.
There's two ways of looking at it. We can look at the chipper way, or we can look at it from your perspective, which were the core which was still left intact and which now the abrogation completely, sort of.
It is also a full chart. That what was the position on 4th of August 2019, even after application of these constitutional application orders? What was the position as on that date? That's what you wants to know.
Yeah.
Some of the articles which I read.
Every one of those provisions which was modified as on 4th of August 19, if you can give us the core to sort of buttress your argument, that look, despite the chipping away, this core had remained intact as on 4th of August 2019.
Very true, I can give that. We still had some autonomy. I'll give some fundamental, let's say NT 97. But you may not go into that far also. I can give example of the best example, NT 97. Who had the residuary power? Who had the residuary power to legislate?
Interestingly, both the state list and the concurrent list were deleted in application to the state of Jammu and Kashmir. You will find that, I just saw it a little while back.
That's why I think it is definitely.
Part 11, see page 16. Page 16 of volume 3, if you're on the same volume.
Yes.
It says in Article 246, the words brackets and figures, notwithstanding anything in clause 2 and 3 occurring, and clauses 2, 3, and 4 shall be omitted. So basically what happened was, in relation to the state of J&K, you had only the union list which was existing. Insofar as it applied to the state of J&K, the entire state list and the concurrent list had been deleted.
But subsequently, you also see this.
Thereafter, maybe some items in the state list were brought in, maybe the concurrent list was also brought in.
I think you also needs to give me some time. It is also subsequently changed in CO 66. This 246, which is also read, clauses 2 and 3, occurring in clause 1 to be omitted. That was the original one. 3 and 4 is also omitted.
So really speaking, we therefore take it, Mr. Shah, that we don't have to go through these articles to buttress your point, but your contention is that there was a very substantial degree of autonomy which was reserved to the state as a consequence of Article 370. That was not merely with reference to enacting laws, which we saw in clause 1, but it was also in relation to other provisions of the Constitution, which would not apply unless there was a concurrence of the state.
I thought I would indicate in specifically, one would be a general position of law, that there was a constitutional autonomy with you. What earlier it was, if I put it in terms of quantum, if it was something like 100 grams, but even then I retained 30 grams by the time it was 4th August.
Perhaps,
But it's
Mr. Shah, what you can
the-
do is, maybe without us going into it right now, later on, even after your argument is concluded, you can give us the core areas which had remained for the state as on, the original Constitution.
Specific area, I can give.
You can give it to us as of, say, the 1954 order.
Yes.
And then you can give us what still remained with the state as on 4th of August 19. So we can have a comparison.
Yeah,
You can do it in 2 pages, that's all. Don't give us a very elaborate statement. That will buttress your point. So we appreciate it. That's all that we.
I had done it my way. I had done it specific article wise. Each and every article, that's what I was trying to show. But if you also want me to give it writing, I will give that.
I think just, on a page,
Show
one page of the position as it stood in 1954, one page is the position as it stood on the eve of the abrogation. That will really support your submission.
But I'll give that.
So that we don't have to then read individual articles unless there's something key that you want us to see,
What's important is this, as I said earlier. Why are we aggrieved of 5th and 6th? If nothing was with us. Why are we aggrieved? Why are before 22, 25 petitions have been filed? There was something with us. I was trying to show what is that was with us. Otherwise, if there was nothing with us, it would not matter. It was an empty formality. Whether you do it or not.
There was something with you, and
Yeah.
there was an
No, whether they could take
emotional
it away.
context of it.
Whatever little sir I had with me as a constitutional autonomy, whether they could take it away.
No,
Not
that's why I
that little.
said 2 things, emotional context and something which remained, actually also remained.
True. What I'm submitting is only, I'm in a response to only Chief Justice's observation, that you indicate only what kind of autonomy you had on that date, on 4th of August. I will certainly indicate that.
And even earlier, because that will support your submission.
This was earlier what I had in 54. Is it also willing to go into the question that 54, what you got, and over the subsequent CO orders, what you lost at what stage? I can take one by one 2 lawsuits on that. What I lost subsequently, but ultimately it ended up on 4th.
Yes.
But if what you say is on
You're
4th,
ultimately
what autonomy
concerned
you
with-
had, indicate that, I will do that.
On 4th August,
I did have my
As three
autonomy.
seventy stood, what is that which was with you, which you have been denuded of by repeal of it?
So take it on the face of it, I can say so just from my heart without supporting it. Let's say, because I was a permanent resident of the state, I had my own law. I had own privileges, own rights. Isn't that taken under? It's as simple as that. It's to your lordship's knowledge. As simple as that. My state could not have been divided into union territories. Isn't that taken away? Honorable the Chief Justice says, you tell me the solid ones which you lost, not the other things appeal to Supreme Court or otherwise. These are few of the solid ones which come to one's mind. I lost that. I lost my legislature, lost the power to make the laws in respect of those matters where it had the power, maybe little power, but it had the power, particularly entry 97. It made certain laws, it made certain changes, but now that is also gone. Preventive Detention Act is also gone. You also have seen the Reorganization Act, how many laws have been repealed? Consequent to
Mr.
this.
Shah, to buttress your submission, we are saying something, which will enhance, which will further your submission. Just look at page 16 of volume 3, in case, I don't know if you are using the same, we are on the same page.
I'll just have a look.
Volume 3, page 16,
1/6, sir. Just
1/6.
I have mine. This
Mr.
digital.
Satyanarayana, somebody can give that.
Yes, sir.
Shah, so that we are on the same page
It's
then.
not 16.
Page 16, you've got that middle of the page, part 11. Part 11,
Oh,
PDF page 16,
yes, sir.
right? So part 11, right?
Yes, in
A.
Article 246.
In Article 246, the words, brackets and figures,
2 and 3, article so and so shall be omitted.
and clauses 2, 3, and 4 shall be omitted.
Yes,
In other words, Article 246, which recognizes the power of the state legislature to enact laws on the state list, and the the power of Parliament to enact law on the concurrent list, was deleted in 1954.
yes.
Now, just go to page 19, PDF page 19. Go to the 7th schedule, page 19, you will see entry 22, 7th schedule. Just give Mr. Shah the page, Mr. Shankar.
19, this was CO, this is CO 55?
No, 54. We are on CO 54 only now.
Just 1 minute, I'll show you.
3 pages down,
Here.
just turn to where
Yes, sir.
the schedules are listed.
7th schedule, yes.
Right. Now, in the 7th schedule, in the union list,
Yes.
just go a little down, item 2, where it says entries so and so, the words interstate migrant, and entry 97 shall be omitted. Therefore, entry 97 is completely omitted.
Yes.
Now, go to the last clause of 22B. The state list and the concurrent list shall be omitted.
Yes.
So, the net result in 1954 was, Parliament had the power to enact laws with respect to some entries in the union list.
Union list, yes.
Parliament, the entire legislative domain of Parliament on the concurrent list was obliterated, and the state list was also deleted because the entire power of legislation, the legislative power, was given to the state legislature. This is the autonomy which you are saying,
Yes.
isn't it?
This is what I thought, but I could specify also what was left. My next question is very extremely important. What was left on 4th of August? I said.
Now we'll go to the 4th of August because that's the part, the chip away there.
What the chief is pointing out in a larger conspectus, what you are saying is 54 reflects a larger conspectus. Larger conspectus is that list 1 as specified, list 2 omitted, list 3 because list 2 already vested with you. Thereafter, as you say, chipped over. So this gives the larger, in support of your argument, the larger context of it.
No, if I am satisfied, not me, your lordships are satisfied that on 4th of August, there was constitutional autonomy, some constitutional autonomy. What was its quantum? How much it was is a matter of detail.
Reflected in it at lunch, we're almost in the stroke of lunch. One way of our doing it is, after the 1954 order, read every order and see the chipping away process.
This is what
That will unnecessarily take a lot of time and it will be tedious. What we were suggesting was, that you can give us the net position as it stood on the 4th of August 2019. So we'll realize then, we've now seen the 1954 order, which gave a very substantial autonomy. No doubt about it. That point you have made. We need to labor the point further. Now we look at what was the position on the eve of the abrogation, which is 4th of August 19.
Yeah.
Because your argument will be that even as on the 4th of August 2019,
Yes.
notwithstanding all the subsequent application which took place, there was still a core left with the Jammu and Kashmir State Legislative Assembly.
That's
So you can give us, like we have now done for 1954, some 3 or 4 examples, and you can put the rest on a piece of paper, just sort of putting it all together.
I can put it entry wise, this entry, this entry, this entry, that I can do.
But just confine it to the key areas, because that will buttress your point, isn't it?
That's the problem, which is a key area. It would be-
No, I mean,
I have some.
Where the rub
example,
lies.
States being together, unified state is a key area. Who is a permanent resident is a key area.
right.
These are the key areas.
So can you just summarize them after lunch for us? Which are the key areas, so that then we can move on to the rest of the argument.
I'll do that. So that,
Got the drift of the argument. We just thought that we should have some illustrations, which are the key illustrations that will sort of, drive the point home.
unless your lordship were writing the judgment, would be very specific. Look here, the state still enjoyed its autonomy in respect of A, B, C, D. That's been specific.
Right.
Second would be, also would say they did have some.
What has
What
been
was
taken,
that, sir?
what has been taken away by the child under the provisions, which are
Yeah,
you
What
understand?
has been taken away, what was left with us? What would be general statement making, sir? I had, as I tried to give example, 100 grams with me, they took 70, 30 still with me. But what was that 70, what was that 30? I thought that I would deal with it in more specific terms. This is taken and this is with me, rather than being general about it. That's what I was trying to.
The only thing is time in all this becomes a little constraint. Now, yes, there was a position in 1954. We've understood your position in 1954. That at various times to time, something may have been chipped away.
Yes.
Is there, when and how is not before us. Because that's a post facto situation.
Yeah, very true, very.
As you also argue.
Very-
Now, something happened which is under challenge. So
Yes.
a pre-challenge position for us to appreciate, what was the pre-challenge situation which has been deprived in the result of what you have challenged?
Yes,
So
yes.
this was
Very
the
good.
correct step.
I'm with your lordships. I'm with your lordships.
We have understood your broader arguments on consultation and concurrence. Now we just would like to know what was the residuum which was left on the eve of the
What
abrogation.
was left of constitutional autonomy? It was in simple language.
As you said,
What is left of constitutional autonomy?
there was something left. What is that something is the only thing we are wanting to know.
All right, we'll just look at it after lunch. And just, yeah, one, two, three, take a look.
Part 6 was not applied.
Go ahead. Mr. Shah, now what is a rough time estimate for you to complete?
I need to still argue, so I have some problems I need to argue.
About, should we give you another hour or so? Can we wrap up in an hour so that then
No,
the
sir, no,
next
sir, actually
person?
more than that. Actually more than that. I would repair it might spill over even because I have some more to say.
I know all of you have some things to argue. Our constraint is also at some stage, things have to end.
Give me
Therefore,
that little freedom.
with
because-
all your ability, I'm
As
sure
a-
you can, with all your
as a
ability, you can.
Important case for us.
Of course, we understand.
Important
That's why
case
we are
for the
giving so
state.
much of time.
And
Of course,
there
Mr.
are
Shah, no
some freedom
doubt about
given.
it. Mr. Shah, can we do this? Can we suggest this after lunch? You can give us broadly the themes on which you are going to argue. Just formulate the themes so that we also have a clear picture that how you are now going to unfold the rest of the argument. Just give us the 3 or 4 themes that you're going to argue and show us under that theme, then we'll know what exactly you are,
As you know.
that will be better.
All right.
Thank you.
Thank you.
Photo, yeah.